Well, welcome back, and we're back with Indian country. I'm going to have some readings posted for you pretty soon. We're going to actually start reading quite a bit. So, and among the readings will be this book, which is your only textbook that I've had you purchase. And we're not going to read the whole thing, but we're going to start reading it for the second and the third exam. So, for the most part, I'll list those readings for you online. I would go ahead and start reading the prologue and the introductory chapter by Terry Anderson and Brian Leonard, called Institutions and the Wealth of Indian Nations. So if you have this book, go ahead and dive into that. Today we're going to talk about water law, Indian water law, okay? And you might be familiar with this, working with BLE, or is it Reclamation? You work with Reclamation. Oh, great, okay. So this might be familiar to some of you. It's actually, to me, it's really complicated stuff, and if you have any questions whatsoever, stop me, and we're not going to, this is not going to be terribly complicated, but there are quite a few dates and cases that you'll need to know about. I'll make sure we get those listed and linked online for you. So rather than dabbling our toes in the water, we're just wading in gradually. We're going to go ahead and dive in. And come on now, help me out.
Here's water law.
Water law. Okay, so there we go. Yeah. So and I'll try to put some of this stuff on the board here, but. Well, actually, I should put some terms up here that are really terms you really should know about. Hey, you can actually read that chalk, can't you? It's great. In terms of Indian water law and water rights in general in North America, there are really two sort of bodies of water law in the United States. The first one, which is more important in the East, and the one that was introduced by the English early on, and it's associated with the humid parts of the eastern half of the continent, referred to as riparian rights. No idea. Oh, yeah, I don't know what it was. Riparian water rights, or the riparian system of water rights. And like I said, this is associated with the English, with the Northwest Europeans, who were really not at all concerned about things like irrigating crops. Okay. And the second one is the one that we actually are concerned about, and this is goes by a couple of different things. I've seen it referred to as appropriative water rights, or the doctrine, more commonly you'll find this, the doctrine of prior appropriation. Doctrine of prior appropriation. Now, a little bit about that law, or this body of law. This one actually comes from Roman precedents. And of course it was introduced by the Spanish, mostly in places like New Mexico early on, later on Texas, California, but most of the American West would fall under, much of the American West, particularly the Southwest, where irrigation is critical for agriculture, would come under this doctrine of prior appropriation body of law. So for the riparian system, we'll just talk a little bit about that. Under the riparian system, which was evolved from English common law, okay, in the English common law tradition. The water that is in a stream, or I guess the rights to water, are simply a part of the property rights. So if you own land and a stream is passing through your land, you have, for the most part, whatever right you want, or you can do whatever you wish with the water. You can dam it up, build a lake, you can utilize the water for irrigation. There's no really control over the use of the water if you're using it within your fee simple property rights. Water basically goes with the land, the property rights. And that's largely because there was no concern for irrigation among most of the English early on. The appropriative system, on the other hand, is one in which there is a recognition of the need of people along a stream, recognition of the need for irrigation water along a stream. And it's more associated with Southern Europe and places that experience drought and places that are more dependent on water for survival, for livelihood. And in terms of water rights, I should mention that in addition to irrigation, other users of water and irrigation for crops, other users of water would involve ranching. Okay, so raising livestock, cattle, particularly cattle and sheep. So livestock production, livestock ranching, and then other uses like mining. Mining depends on exactly what it is, but mining is often a great user of water, and we find lots of mining operations in the West. So where we don't have a lot of water available necessarily. So, two bodies of water law, one associated largely with the eastern United States where irrigation is not significant, and the rest the western United States, particularly west of the Great Plains, and especially the Southwest, where you have a Spanish heritage. In the case of the second one, this is what we're going to spend most of our time on, the doctrine of prior appropriation. The water rights are separate from the property rights, from the land, the ownership of property. So unlike the riparian system in the, let's just call this prior appropriation. And you can kind of think of it as surface rights versus mineral rights. If you're in Oklahoma, you're familiar with, petroleum, oil and gas production. If you own the surface rights, maybe you have a farm or ranch, but you don't own the mineral rights, then whoever owns the mineral rights can lease those out to any, oil or gas developer, and they come in and they'll get what they are after, and they'll pay the royalty, whatever that may be. They'll pay that royalty to the owner of the mineral rights. As a surface rights owner, you're only going to be entitled to reclamation costs and, what do they call those? Basically inconvenience costs, and you're not going to be making a lot of money. But and often that's where a lot of problems come about with oil and gas developments between the surface owners who don't have minerals and the oil and gas exploration, oil and gas production side. So, but in prior appropriation, it's kind of like that because the water is kind of like a mineral right. The water is separate. But the water is different from a mineral right in that the water is largely a communal resource. It's a resource that, under this system, is shared with people who have access to water on their land. So the water and the property, that is the land surface rights, are separate. The water is distributed in a hierarchical way, and this is where it gets kind of complicated. The term prior appropriation kind of directs us to what this means. Basically, the rights to water on your surface property, the rights to the water belong to the first claimant of the land. And if you've purchased land from somebody who was an early claimant, then you basically get those same rights. Okay? So essentially what that means is the earliest settler, the earliest land claim in a river basin or a valley, a drainage basin, has the highest degree of priority, or has the priority over other people who came later, or other settlers who settled later. So this is what in a prior appropriation system, what matters is kind of the genealogy of where you live, or your ranch or farm. How old was that established? If it was before everybody else, then they have that right to the water. Now, it's not as simple as that, though. If the other side of that is someone who has an early property, or has an early water right, or has prior appropriation compared to everybody else, someone has that old right. If they don't use the water in some way, through irrigation or diversion of some sort, then they don't get to claim it. All right? So this is, in a sense, remember that term usufruct, property rights, or usufructory? It's related to that. So you cannot have, like in the case of the Cherokees in the 19th century, you could claim land all you wanted, but you had to have an improvement that was provable on that surface. And you could claim a quarter of a mile in any direction from that improvement, whatever it was, but you couldn't claim land that you didn't use. And similarly, under the prior appropriation system, you can't claim water that you're not using in some way. In other words, if you're not going to use it, you lose it. You lose it to the next person, the next oldest water right downstream. Okay, so basically, the rights to the water under prior appropriation gives precedence to those people who have the oldest claim, and it requires them to use that water, or they turn it over to other people. They pass it on down the line. All right, so if a particular claimant is subject only to the demands of anybody within a watershed, let me draw a dendritic drainage pattern here with tributaries and so forth. Someone right here, of course, downstream is going to be dependent on people up here and the tributaries, right? So what this is saying is that, and this is often the case, somebody who's downstream has an older claim to the water. I'm Porky Pig this morning for some reason. I can't get the words out, so maybe y'all remember Porky Pig? Maybe? Okay. Maybe I'll post something on Porky Pig. Anyway, so you have these claimants up here, and if this is an older claim to the water, and they have an older right, a higher priority right, then these people have to recognize that right. They have to provide a certain amount of water to this person down here. Now, if this is the prior appropriation up here, and this is a later a later claim, then, you know, this guy's kind of out of luck, right? So it's all about timing and history and also utilizing the resource. It's really important that we recognize that this is a system that is designed to allow, sort of maximize the water usage. Now, what happens during a drought? In the case of a drought, when people are using perhaps more water than is even available, then the oldest user is going to be the one that, you know, has the better chances of survival. You know, if it's a crop production, if it's a farm or something. And the latest appropriator is the one that's going to lose out on those water rights and will have to fold or something, or may lose money. So whenever there's a crisis of some sort, a drought, then you've got these rules that kick in, and if people are abiding by those rules, then the older claim is the most secure claim, okay? The most dependable water supply. Now, the other thing about this, water is also a very difficult subject to discuss in terms of resource allocation, because not only is it you know, subject to certain types of legal systems or claims, but water is not stationary. It's not in one place. It tends to move. And as water is moving through a drainage basin, a watershed or something, as water is moving through that, it's bound to cross jurisdictional boundaries. It's going to cross jurisdictional boundaries. So, in most cases, in the United States at least, it is the purview or the prerogative of states to regulate water. Okay? States are generally the basic regulators of water, and so each state has its own water policy or set of water right law. Now, there are some states that are purely appropriative, purely Western style, like Colorado. Colorado is a prior appropriation state. And there are other states that are mixes of the riparian system and the prior appropriation system, particularly those that were colonized, settled early by the English. Oregon, Washington are examples. California, actually, too. They're kind of a mix. They have kind of, their state regulatory law is kind of a mix of these two systems. So every state's a little bit different in terms of their water regulation system. And that is where, that of course, because of state regulation, is where it gets even more difficult when we start talking about Indian land, okay? Indian country. So you've got the intro to a little bit of water rights. We're saying that water is regulated generally at the state level. It's the state's prerogative. And every state's a little bit different. Some are riparian, some are appropriative, some are mixed. But the idea here is that states have the authority over these resources. And this won't be the last example of that. States also have the, more or less the authority over other mobile resources. Okay, like what? What's another example of a resource that, a natural resource that is unlike, let's say, a deposit of natural gas, which for the most part ain't gonna move around too much. And I'll give you a clue. Archery season started the day before yesterday.
Just like deer and antelope, all that good stuff. Just the
Wildlife, yeah, wildlife fisheries. Wildlife and fisheries are, wildlife, as maybe you already realize, is not attached to the land, okay? Wildlife is a natural resource that you do not own if you own the property. Okay? A lot of people don't understand that to this day. You know, that's why when you see the high fence deer farms, right? Ashley, you're a deer hunter, aren't you? That's what I thought. Okay. So when you see the high fence deer farms, right, with 10, 15-foot fence, you'll see signs that say, "These deer are livestock," right? Because you're not supposed to fence them in. You're not supposed to be able to own them like cattle. But that's a different story. Anyway, natural resources like wildlife are mobile and they're not attached to the land. Therefore, a property owner cannot say that these deer or these ducks especially are my property because they're on my pond or they're in my forest, my woods, and I can kill them as I wish. Okay, can't do that. That's a different type of resource, a mobile resource. So water is a mobile resource, and so we have a fairly complex system of laws. And again, it's state level law, and that of course is going to be a problem when we start bringing in Indian tribes and rights to water. So the most important, most basic starting point for understanding Indian water rights is something we refer to as the Winters Doctrine. Or what are referred to as Winters Rights. This refers to a Supreme Court decision and the case was Winters versus United States, and it was in 1908, and I'll put the citation up for you later, but a 1908 court case that was a Supreme Court decision involving the Fort Belknap Reservation in Montana. And so we need to talk a little bit about what happened and the historical grounds of the reservation and what became of this. So the reservation, the Fort Belknap Reservation, was created in 1888. Okay, is that early or late in the reservation scheme? Kind of late, isn't it? I mean, 1888 is after the Allotment Act. So it's a kind of a later reservation, and a lot of those later reservations that were established in the far west and the Mountain West, a lot of them never even underwent allotment. A lot of them never had time to undergo allotment, and certainly didn't lose a lot of individual Indian lands through alienation of allotments, because John Collier got to them faster than the others. So the reservation has a boundary that includes the Milk River, and the reservation was actually established by not a treaty, right? How was it established? By an agreement, a so-called formal agreement. So it's like a treaty, but no treaties after 1871. But it's an agreement, and basically that agreement involved defining territory, identifying land where Native peoples lived. And so anyway, the boundary of the reservation included the Milk River, which is, following one part of it. It's just the boundary of the reservation, not flowing through the reservation necessarily. Okay. Sorry, I should have a map here, but maybe I'll try to post a map for this. The boundary of the reservation then being the Milk River was listed in the agreement, but no discussion about usage of water from the Milk River was in the agreement. Now, by 1888, it wasn't very long after the reservation was established that non-Indians began to settle in the area, attracted to land along the Milk River, and land that could actually be diverted for irrigation use, for agriculture. That's a little bit later, but essentially the agricultural settlers along the river began to utilize the water that the Milk River had upstream from and adjacent to the reservation. They began to utilize that water, and there was just simply no recognition of the rights to use of that water by the people on the reservation. You ever heard of this case by chance? A little bit? Okay. So the court found that there was no point in hearing whether Indians were even using the water in this case. Since the reservation was created, what the High Court found was, and this was the important part of this decision, was, okay, the United States government established a reservation for this Indian tribe. The whole idea of a reservation was to make presumably nomadic people, or not so sedentary people, sedentary. The whole idea is to make them sedentary farmers, right? If not ranchers, farmers, but they wanted them to be in one place. That's the whole idea of a reservation. Another idea of the reservation is this is federal land. It's Indian trust land, but it's federal land put forth for exclusive use by this particular group, this Indian tribe. The Indian tribe then is obligated to utilize, they have the rights to utilize all the land within their reservation. But the whole idea of a reservation is to get them living in one place, which presumes that they would be agriculturalists. So the Supreme Court of the United States found that just the whole existence of a reservation implies farming and agriculture. And because it implies farming and agriculture, it also implies these people have the right to the water available on that reservation. They have the rights to the water. That's what the Winters rights are. So the Winters Doctrine, 1908, states that any water that is accessible by reservation Indians within Indian country, any water that is accessible to them, they have the rights to use. Now, up until for the 20 years up to the decision, it was, there's no law. Basically, and this happened a lot, basically the non-Indians utilized the water because there was no law explaining that they couldn't, and it was unclear as to what sort of claim the Indians may have had on it. But this was the most important decision to establish Indian water rights. Now you would think, okay, well that's good for the tribes, right? At least the tribes get to utilize the water on the reservation. However, as often is the case, from about 1908, the establishment of Winters' rights, until about 1963, we find that Winters' rights are largely ignored. Indian water rights tended to be ignored by, believe it or not, the federal government. Now, at this point, we need to have a little bit of history of what's going on in the West in the early part of the 20th century. And if you're unfamiliar with that, this period, particularly between the 1930s up until about 1970 or so. But the 30s, the 40s, the 50s and 60s, especially the 1930s and then the 50s and 60s. Those were decades when the United States Army Corps of Engineers, like the Tennessee Valley Authority in the east, the Army Corps of Engineers built numerous large dams across the dry west, across the mountain west, California, the Great Plains. And what were the purposes of those? Well, first of all, let's go back. What's one of the largest dams in the United States that you can think of? Well, what are the largest dams you can think of?
Hoover Dam.
Hoover Dam, yeah. So when was Hoover Dam built? It was called, anybody know? Boulder Dam. Originally Boulder Dam. And they renamed it later for Herbert Hoover. But that was a big project of really the pre-Depression years. It was, it started, I believe, in the late 20s, or maybe around 1930 or so. But of course, it was a massive federal project, and the whole idea was to, dam the Colorado River so that you would have the massive amount of fresh water available for urban growth, urban demand, and of course, what else? Hydroelectric power, hydropower. So, and that, Hoover Dam was just one example of many, many examples. Lots of examples in the eastern United States that were primarily dam projects that were built for flood control, for navigation, development of inland navigation, for hydroelectric power in some cases. The TVA, for example, built a lot of hydro dams that not only would eliminate flooding, but it also created electricity for people that didn't have electricity, and also allowed, the whole idea of the TVA was to develop the Appalachian region, and one way they saw doing that was by providing very cheap electricity to basically subsidize industries. And then when World War II hit, aluminum smelting and all that requires a lot of electricity. That was like good timing because the aluminum industry was important for the aircraft industry and so forth, and fertilizer production and all these other things. Inland navigation later. In Oklahoma, we got the biggest pork barrel project of the century with the McClellan-Kerr Arkansas River Navigation System, which involved all these dams and locks that allowed barge traffic to get all the way to Catoosa, Oklahoma. But in the West, it was largely about irrigation. Irrigation and hydroelectric power were these really huge dams. Big projects, largely funded by the federal government, with the idea that these big federal spending projects, which of course the congressmen, did their best to grab. Federal money coming into the West it's a tradition in the Western states to suck up federal money and then complain about the federal government. Okay, that's a tradition in the United States. So they were getting all this federal largesse, right? Getting all this federal money for building big projects. A lot of that, was justified because that water that would be impounded on some of these big rivers, big western rivers, that water would then be used for subsidizing irrigation agriculture. And you have to have irrigation in a lot of these areas. So what type of crops for irrigation? Well, things like sugar beets initially, in the Platte River Valley in Nebraska, other places upstream. But other things, and sugar beets, of course, not much of a market necessarily there, but other things like even alfalfa. What are some other crops that are irrigated? Well, you can grow pretty much anything if you're irrigating, right? You can grow corn if you need to. We do that in the panhandle of Oklahoma using center pivot irrigation. But essentially, these big, large federal projects were intended to subsidize agriculture, to provide some sources of power for cities, maybe recreation to some degree, but these were the intents, okay? And throughout the 20th century, the first half of the 20th century, the federal government came in and built these dams, provided a lot of jobs for people, and really important during the Depression. And so there was really no question about, well, what if there's an impact of water usage on Indian reservations? So what I'm saying is that the federal government spent billions of dollars developing Western water infrastructure during the 60 to 70 years following the ruling that created the Winters Doctrine. So it's the federal government, essentially, that is ignoring this potential issue. The federal courts then put tribes behind the general public interest. There was not a lot of ruckus by the tribes during this time, and of course you can imagine during the New Deal era, during the Collier days, right? The Indian tribes were being revived to a large degree. I mean, they were writing constitutions and creating tribal councils and sort of organizing themselves. And then we go through the 1950s and you have your termination, right? Termination era, where some tribes were getting axed. And it's really the 1960s that brings about any thought about impact of the federal government dam construction on Native American rights, and particularly Indian country. So we'll get to some examples here, but what does 1963 have to do with it? 1963, there's another case, and this is a really, really important case, and it doesn't sound like anything having to do with Indian water rights. It's called Arizona versus California. In 1963, the United States Supreme Court case involved the Colorado River, okay? Now you can probably think of California and Arizona fighting over the Colorado River. Where would that happen?
Vegas.
Huh?
Vegas, I don't know. That area? Didn't East California get their water from Vegas? That whole area?
Well, it's not so much urban use. Where does your salad come from? Probably.
SoCal.
The Imperial Valley, right? Imperial Valley. In the Imperial Valley of extreme Southern California, right? Colorado River. So anyway, what happened in this case was that the water rights of tribes on a river whose reservations had been established by statute and executive order, okay, were impacted by the use of water by these by agricultural irrigation uses. In the case of Arizona versus California in 1963, the Supreme Court held the Winters Doctrine, right? It upheld the Winters Doctrine and ruled that any reservation established would imply that government intended farming, and this by nature implies water rights are necessary to allow the land to support the people living on a reservation. Okay. Now, what this did, initially the question was, how was the reservation established? Was the reservation established by congressional statute or by executive order. And you know that in 1919, reservations were no longer established by executive order. That was finalized. There were no reservations established after 1919 by executive order, only by statute. And this is a case where the question was, well, what type of reservation is this? Was this established by treaty, formal agreement, executive order? With the executive order reservations sort of having a lesser status. So the Supreme Court ruled that it didn't matter, that any reservation at all is going to imply water rights for Indian people, the users of the reservation. Now, but it was a little bit more complicated. The people who were the non-Indian users of the water, the people who were the non-Indian users stated that, look, there's a tiny population of people on this Indian reservation that are getting claim to a large amount of water. And they don't need it all. And therefore, we're in a state where, there's a mix of riparian and prior appropriation law. So it's kind of gray as to the way the state rules this, and the federal government has to iron it all out. We've got two states with different water laws, and but what happened was the Supreme Court, in its opinion, ruled that didn't matter. Okay? It didn't matter that if a tribe has a reservation, if water is flowing through Indian country, the tribes are allowed to irrigate all the land that they could possibly irrigate. Okay? Now, this brings us to another term. It's getting fun now, isn't it? How many of you all use geographic information systems? 1, 2, 3, good. And not just the geography majors, right? Well, we've already seen a need for GIS back in 1887 and afterward with allotment. But man, oh man, now we've got a mobile resource. Now we've got a natural resource that doesn't stay in one place. And we've got the Supreme Court jumping in trying to fix everything. We're trying to at least clarify things for us. Okay. So the court came up with a concept. The Supreme Court said, it doesn't matter how many people are on that reservation. If there's 10 people on a reservation of 30,000 acres or 200 square miles, they have the right to everything within that reservation if there is land, basically, if there is land that can be irrigated. So a reservation implies agriculture. Agriculture in a dry land environment implies irrigation. And it doesn't matter how big the reservation is. What matters is how much land could be utilized within that reservation with irrigation. That's a lot of TIONs, sorry. And so the concept that that emerged with California versus Arizona is something called PIA. You know what that means? You heard of that? And this is a difficult word for me to say and even spell, so PIA, practicably irrigable acreage. Try saying that 3 times real fast. Practicably irrigable acreage. PIA. That is a measure, okay, that's a quantity of land that could be irrigated for agricultural use. So how do you measure practicably irrigable acreage, the amount of land that could have agricultural potential if it were irrigated? That means that every reservation, let's say, maybe we've got 300 reservations left, and perhaps among all those reservations, there are some that are in dry regions where there is enough flat land that might be able to be utilized for irrigation agriculture, right? So here are, we'll call these the reservations, and basically what this created was a system of quantifying the amount of water owed to a reservation, or the amount of water that a reservation could potentially claim based on the amount of irrigable land, acreage of irrigable land within its boundaries. So, some might be 348 acres, in a mountainous area, or this one might be, or we might say, 1% in some places. And then others, it might be like 60%. It's anybody's guess. Depends on the location, right? So the quantity of water that an Indian tribe can claim for its own exclusive use has to do with the amount of practicably irrigable acreage within that reservation. Okay? Now, so there's a job for GIS. How do you calculate practicably irrigable acreage? All right, now let's back up a bit, and I'm going to provide a little bit of explanation or a little bit of an example here. We'll look at another example, the amount of time that we have, on the Wind River Reservation. Okay. Another case study here. Where is the Wind River Reservation? Anybody know? Wyoming. It's in Wyoming. And it was established pretty early, 1868. I don't know if it was with the second treaty of, what was it called? Anyway, the reservation was established fairly early in 1868. It's located in west central Wyoming. It's a huge reservation. It houses, the reservation was established for two tribes, so it's a compound tribe reservation. The two groups were the Eastern Shoshone, or Shoshone. Seems like when I hear it in the movies, it's Shoshone, but when Indian people are referring to themselves, they say Shoshone. So I think it's Shoshone. And then the Northern Arapaho. Now the population in the year 2000 of that reservation is far more than it was when it was initially created. Today the population, or at least in the year 2000, the population of the reservation was 40,237, okay? Now, as you probably realize, not everybody among that 40,000 or so folks are American Indians or even tribal members, okay? So, but that's, that's a typical case. In the case of the Indian population, I'm sorry, the population was much more than 40,000. There were 40, scratch, cut, okay? Erase that from your head. It's like, you know, what do you call it? Men in Black. Erase that. Flash. I wish I had that, by the way. It would be fantastic. 40,237 tribal members on the reservation. Okay? I don't know what the actual population is. 40,237 tribal members, 54% Arapaho, and 30,000 Shoshone. Now, what that really matters, I can't really remember, but here we have the population is associated with the calculation of the practicably irrigable acreage figure. Okay. So the practicably irrigable acreage is a fixed number that is associated with the future water needs of the people for whom the reservation has been established. Okay? All right. Now, under the Winters rules, tribes can use water for any purpose. It's just determined, the amount of water is determined by the amount of land that can be practicably irrigated within the reservation. All right. So it's dependent on the amount of land that's not like mountainous and rocky or something. But the amount of water that they can claim doesn't have to be actually used for irrigation. Okay. Helpful. So everybody clear on that one? So the amount that the tribe can claim is based on this irrigation idea. That's what they're owed. But they don't have to use it for irrigation. They can use it for other purposes. Now, of course, agriculture and irrigation is typically the most, it's the thirstiest user of water we have. If you look at the amount of water used in Oklahoma, what county uses the most water every single day?
Texas County.
Is it Tulsa County? Is it Oklahoma County?
Texas.
It's Texas County. You knew that, right? It's Texas County. We're in the middle of the panhandle, Guyman, and it's the amount of water that's used for irrigation. And that's probably not all throughout the year, but in other words, we use a lot more water for irrigation, even in Oklahoma, which is not a major irrigation state. We use a lot more water for irrigation than we do even urban use, residential or industrial. Industrial use can get pretty high, but for the most part, and even most residential use, it's irrigation too. It's watering lawns and that sort of thing, a lot of it. Okay, well anyway, what are some other major users of water? Well, other than agriculture. Things like milling grain uses a lot of water. Of course, power generation uses a lot of water. Refining raw materials often uses a lot of water, whether it's like paper pulp or even sugar refining. Other types of agriculture can utilize a lot of water, like production of poultry and eggs, manufacturing of food products, production of chemicals, and the processing of metals uses typically lots and lots of water. Well, there are some uses of water in Wyoming in particular that have, especially recently, come into the news, and of course one of the big users now in Oklahoma and North Dakota and other oil-producing states in the West, one of the big controversies with hydraulic fracturing is its demand for water. Okay, and that's a legitimate claim. It is a major user of water locally, and you know, it is perhaps impacting during boom times, impacting available water for other, it could go for other uses, agricultural uses, if that's anything more important, which I won't say. Okay, so in 1906, the Wind River Reservation was allotted. All right. So it was allotted, but it was allotted to the extent that the Wind River Reservation was being considered to be non-existent anymore. Okay. Now we get into a new term, and the term is diminishment. Wind River Reservation was considered to be diminished. So here's where we get issues with practicably irrigable acreage, population of people who can use it or not. We have issues with whether or not the reservation is even legitimate anymore. Does it even exist so that the tribe can claim it, etc. All right. Well, we'll look at another example next time in California. But at this time, what I'd like to do is just summarize the winter's rights a little bit, just so we have those on record. Summarizing winter's rights. What does that mean? What are winter's rights? Number one, this is a federal ruling. It's a United States Supreme Court determination, 1908, and so this is federal law. That's important because, remember, Indian tribes are outside of the jurisdiction of states unless the federal government has handed the states jurisdiction. Number two, so this applies to Indian country, period. Number two, any type of reservation, however it was established, will imply that water rights exist, right? And that's not just within the reservation, but if a river is serving as the border of a reservation, that's considered to be water that could be utilized by the reservation. So, how can we put this? The establishment of a reservation, whether by treaty, statute, or executive order, doesn't matter. Any type of reservation, by any means. Good question. Any questions over here? Good question. Thought I saw a hand go up. Number three, water rights. Number three, water rights are reserved at the date of the reservation's creation. All right, so in a sense, this is kind of like prior appropriation. It does matter when the reservation was established. In the case of the Wind River Reservation, all the way back to 1868, it preceded any other settlement in the area. So they have pretty exclusive rights. Now, what did Collier do to reservations in the 1930s, you recall?
He's trying to integrate them.
Yeah, he tried to stop them from being dissolved and diminished, and in some cases, added land to them. Oh man. Okay, so now we have reservations that weren't just created in 1868, but maybe were created in 1868, perhaps diminished through allotment, but then new lands purchased by the federal government placed into trust so that there are newer parts of the reservation. Right? And if they're newer parts of the reservation, like established in the 30s, then they're going to be established after other users who have prior appropriation. So water rights are reserved for Indian tribes at the date of the creation of a reservation. And if a section of a reservation is added at a later date, its water rights, or the water rights in that part of the reservation, start then. They start later. They start when the new reservation was established. And competing prior appropriators, that is, competing water users who have an earlier appropriation to the water, have precedence over the Indians. Okay? So it's possible, very possible, that you could have a superior right over the water rights that the Indians have on their reservation. And to add to that, those with later dates are then subordinate to tribal rights. So an Indian reservation is going to have priority over later settlers, and those settlers have to, if the settlers say, or for example, the settlers are upstream of the Indian reservation, they have to provide the water that the Indian reservation is due. So it affects upstream and downstream. Number 4. The amount of water reserved for a reservation is equal to that which would irrigate all of the practicably irrigable acreage of the reservation. So this was a later ruling. This was later adjusted to something called, and I'll put this, I'll quote this for you online so you can see it. Sufficient to accomplish the purposes of the reservation, which may or may not be agricultural. Okay? Now get creative. Think of, what if you're an Indian tribe and you've got old appropriated rights because you have an old reservation, you've got very few people perhaps, you've got access to a huge amount of water, and you're not going to use it for irrigation. What can you do? What can you do with those rights? Remember, I guess what I'd like to ask you then is, okay, the federal government establishes an Indian reservation. The assumption is that the people are going to be farmers. The assumption is that in the West, if they're farmers, they got to have water for irrigation, right? So it's all tied together. Now, what about the future? What did the federal government do when it created reservations? Did it assume that those reservations would exist forever? Did it assume that the Native American people that lived on the reservation would be living on the reservation for the rest of eternity? Probably not. But of course, federal policy is usually, a matter of 2 or 6 years, depending on the election cycles, right? Who's getting elected. But the courts come in, and the courts start getting theoretical about all this, okay? And the courts interpret things like this. number one, you can't assume that the Indian population is going to go away. In fact, you should probably assume that the Indian population is going to grow. And you can't assume that the Indian population, even though they are receiving the amount of water based on the amount of irrigable land they have, you can't assume that everybody has to stay a farmer the rest of eternity, right? So you can't assume that the water that they have the rights to has to be used for irrigation purposes. So in other words, what if the Indian tribe wants to establish a steel industry? Then it's their prerogative to use the water that they have coming to them for the steel industry, or whatever it is. So a couple of things there. The assumption, there was probably no thought given to the idea of the future, but the courts come in and say, oh, well, you got to consider the future. We can't just assume that they're going to disappear. So number 4 would be, what would we say? The amount of water reserved is equal to the practical irrigable acreage, PIA. That's what they have the rights to. Now those rights that's the quantity that they have the rights to. They may not have superior rights over earlier appropriators, but they have a certain amount that they can claim. Number 5, let me get out of here. Number 5, this was a good one. Like over here when we were talking about prior appropriation, how if somebody has a prior appropriation to the water to inferior claimants downstream, and they don't use the water, what happens to the water? They have to give it up. Not so with the Winters Doctrine. The Winters Doctrine states that unlike water rights held by non-Indian appropriators, Winters rights are not lost by non-use. It's a lot of negatives, I know. Not lost by non-use. Non-use. In other words, the use it or lose it rule in Western water rights in the states does not apply to Indian tribes. The tribes can claim the water and not use it. Okay? What do you think about that? In 2001, the California versus Arizona case that we talked a little bit about, in 2001, the Arizona Supreme Court, the Arizona Supreme Court determined that the reservation was intended to be the permanent home and abiding place of the tribe, which nullified the measure of practicably irrigable acreage. Oh my gosh! Okay? So the Winters Doctrine has been affected by this. The Arizona Supreme Court takes into account this idea that there is a future for these native peoples, and that whole idea of a practicably irrigable acreage puts a cap on the amount of water that a population that's growing in the future could use. Which in theory, since that ignores the possibility of since the PIA ignores the potential of a population growth, then it kind of it sort of locks Indians in place. So anyway, the court ruled that the practicably irrigable acreage idea is not possible. And this caveat in the Winters Doctrine is now referred to as the homeland purpose of the reservation. All right, the homeland purpose of the reservation. That is basically the amount of water that an Indian tribe can potentially claim is up to however they really want to use it. In other words, the sky's the limit. If they need the water, they get to say they get to claim it. They want, if they say they have a use for it, then they get to use it. So in a way, the Winters Doctrine, American Indian water rights in the West are, you can see, fairly superior to the non-Indian water rights. Okay, even to this day. And that's about all we can cover today, but actually this will continue on a little bit with Indian water rights. And guess what? Allotments are Indian country too. All right? Allotments are Indian country too. And Winters Doctrine applies to allotments.